moving to video conferencing. At that, I will hand it over to our first speaker, Tom.
Okay, thank you. I'm going to share my screen. And there we go. Okay. Thank you to the LERA Dispute Resolution Interest Group and for putting this webinar together. And I want to thank my co-presenters and Mark for moderating. So early in March, as the COVID-19 pandemic gained traction in the media, FMCS put together a strategy memo designed to enable field mediators to run remote meetings. And the memo and the work that followed became very important as the agency quickly moved to doing 100% of our work remotely. The strategy contained two tiers. The first tier involved the Office of Strategy and Development. And the second tier, a new training cadre that we recruited very rapidly from among the ranks of established field mediators. We called them meeting techs, and I'll describe how that group has been working with our field in a minute. So again, Tier 1 was composed of this Chief Strategy Officer and 5 staff from the Office of Strategy and Development. And our first charge was rapidly researching, exploring, and becoming proficient with the virtual meeting platforms that FMCS was already using. And the primary one for meetings has been RingCentral Meetings, which is actually very similar to Zoom. And then we wanted to also become familiar with the tools and platforms that some of our customers were using so that we would be able to, be conversant around those platforms with our mediators who were looking for assistance. The second tier was this meeting tech group. And the idea was to build a team of virtual meeting platform experts to assist all the field mediators in conducting collective bargaining, grievance, and other forms of mediation electronically, as well as any training that was being delivered. We held trainings with the new team, and we called the team, again, meeting techs. And the agency also mandated training for all mediators on the basics of RingCentral Meetings, which is, again, going to be our primary platform for delivering our programs. In the next few weeks that followed, we rolled out a series of demonstrations. We called them sandbox sessions and training programs designed to address the emerging issues that we were discovering really on a daily basis related to the virtual platforms, and to quickly disseminate the information to the field. And I'm just going to talk about how we did that briefly and then turn it over to the next presenter. So we had a series of mandatory live demos with RingCentral, and we conducted these with each of the 8 FMCS districts, which are configured geographically. And the demos were designed to be held in an hour or less, and they were led by members of the OSD team and assisted by meeting techs from that particular district. And then the next thing we did is we developed a survey, and it was using our software that we have called Facilitate Pro that was sent to all the field mediators, asking them to sign up for what we called sandbox sessions. And the sandbox sessions, we took 2 meeting techs and 3 field mediators and put them in basically a Zoom meeting or a RingCentral meeting, apologize. And the idea was to get a chance to just try out the different aspects of the program, to play around, if you will, with the platform in a non-stressful environment before they had to go off and do an actual mediation where they were using the service. So after we had trained a group of meeting techs, the field mediators began sending requests for meeting tech assistance to the OSD email box. And we staffed that, we monitor that box daily, and then we would pair the requesting meeting tech with the requesting mediator and then basically what the meeting tech would do is join the meeting and assist the mediator with any technical issues that may have come up during the meeting. The other couple things we've done I want to go over is we meet weekly with the OSD staff, meets weekly with the meeting techs. We have a meeting on Friday, and it's just what's going on, discussion and planning for emerging needs and that are kind of popping up weekly, sometimes daily. The last thing that I wanted to talk about just briefly was the security issue. As you know, there have been some issues related to security. The way that FMCS decided to address that was first of all requiring a document for all meetings that was basically a virtual service agreement to be used with all online meetings. The idea of the agreement was to address basically three things. Well, four things. The recording of information from attendees. Media must be informed of all people that were in the room, and then addressing confidential information and security breaches. So that is basically what I wanted to share, and I'm going to stop sharing and turn it over to Janet.
Well, actually, hey, Tom, can you still hear me?
Yes, I can.
So Philip Johnson wants to know how does Zoom and what's the difference between Zoom and Ring Central? So I guess how do they compare?
Okay, well, there might be somebody on this call that's better able to answer. I'll give you the layman's version of it. I know a little bit about it. So Zoom and Ring Central are basically, my understanding is they're owned by the same parent company. So they are very similar in terms of platforms. And you may have heard some of the security breaches that happened with Zoom. As those security issues rose up, what I have noticed is that I actually have a Zoom account and a Ring Central account. So I have a Ring Central for work and a Zoom for outside of work. And I have noticed that the company has been addressing the security issues pretty rapidly. They've established a series of, and this is the same with Ring Central, they've established a series of security protocols. We can go through some of those later on in the meeting if you want, but I'll just describe a couple of them. They have a waiting room situation where you can put people in a waiting room and make sure you know exactly who's supposed to be in the meeting before you allow anybody in. And they also have a way to lock the meetings. I'm talking about both platforms now because they're very similar. You can lock the meeting after you know you have all of the participants that are in the room that need to be in the meeting. So there's just a couple of security protocols, but they're very similar. You would need somebody above my pay grade to explain exactly the differences between them. So because it would be somebody in our IT department actually. But I hope that answers your question.
Great. And then James, I'll again, if you have questions, please pose them in the chat. I will manage it. So James, I'm actually going to propose your question to Tom at the end of the session after Janet and Dick have spoken, because they may touch on that somewhat. Okay. Otherwise, Janet, you're on deck.
Okay, great. Thanks, Mark, and good morning, everyone. I'm taking this section without a slide, so in a minute this can get pulled down. And I'll just be talking to you about how IRB has responded to the COVID-19 crisis. Before I do that, though, I just want to say greetings from Oregon and express my sadness on behalf of the Oregon LERA chapter that we won't be having our meeting in June in Portland. We're excited about the virtual option. And actually for the dispute resolution section, we're hoping that we'll have a meeting virtually as well, but we look forward to that opportunity when folks can come back to the Great Northwest. We hope that opportunity will present itself. So Back to the Oregon Herb, I'll just take a couple minutes to kind of give you a quick overview of how we responded. Many of you know that Herb is a small agency with a big mandate. We have 3 divisions: hearings, elections, and conciliation, but we're staffed by just 13 people. And the Conciliation Service side of the house, which is the focus of this webinar, is staffed by three and a half people, 3 mediators, including myself, and a half-time mediation coordinator. So we're the little engine that could, in a sense. We're used to doing a lot with a little. And like many of you, I think when the COVID-19 crisis hit, we knew no one was going to be showing up to save us. So we had ourselves to figure this thing out. We did have a couple of fortunate things that were in place prior to this. We had moved to a case management, electronic case management system a couple years prior. So our constituents were doing electronic filing, our records were digitally stored, and we'd actually moved all of our employees to some level of telecommuting, including support staff. So we were glad that we at least had some familiarity, some foundation to ramp up from. But when it comes to our in-person proceedings, which is the heart of our service, we had not done those virtually. Mediators had used Zoom in a very limited capacity, offering that as a pre-mediation conferencing option. There were times when we weren't able to get across the mountains, and we had facilitations that we were doing on the east side, and we tried to use Zoom for some of those in the winter weather. But other than that, we had not used this technology, and our stakeholders had not engaged with us this way at all. So to date, and it's been about 6-7 weeks, we've been in this situation. We have conducted a number of virtual mediations. We are using the Zoom platform. We're continuing to provide facilitation of interest-based negotiations using Zoom, because we had several cases active at the time of the crisis hitting. We use Zoom meetings for closed meetings. We're actually using Zoom webinar in situations where parties want to open their negotiations up to the public, and that introduces some challenges, and which I'll talk about later in the presentation. We have expanded our facilitation services at this time to include any and all labor management conversations that people are having that they feel they would benefit from having a neutral convener. So we're making ourselves available to help with the Zoom hosting, to help with keeping meetings running in this unusual environment. On the hearing side, I'll just say briefly, we've done some mock workup of Zoom on a trial basis within our office, but we have not actually conducted a Zoom hearing, simply because the demand is not there. Constituents are choosing to postpone hearings at this time, so we'll see how long we're in this situation and what the trend will be. So I would say, to sum things up, we've learned a lot, similar to what FMCS has done, but obviously on a smaller scale. We put ourselves through testing, we've developed policies, we're putting procedures in place, we're learning as we go. But the most important thing here is really our constituents' needs and the appetite for virtual proceeding, and I think those things are evolving, and we're going to continue to monitor those. At the moment, our constituents are out there keeping public services going, and they're hammering out agreements specific to this pandemic. We're just hearing through the grapevine, and we're kind of seeing the evidence of some of the letters of understanding, the MOUs that are coming through. There's a lot of cooperation going on out there. I think there's a lot of conflict as well, but for the most part in this early phase, we're seeing mostly the results of a lot of cooperation and agreements being reached. So we will keep monitoring the situation. Our aim at Herb is to be ready for our constituents when they need us in whatever form that allows us to carry out our mission. So that's a brief state of things at Herb. And again, I'll be talking more about some of the challenges and some of the specific interventions or remedies that we've put in place to deal with some of them with the virtual mediation. So with that, I'll turn it over to Dick.
Thank you, Janet. And Mark, you can go back to my slide. Greetings from Arizona. And the intent of this one slide, which you'll get to, Mark, it's coming a little further back, is to describe the response of my ADR practice, mediation and arbitration, to the COVID situation. As you know, a mediator and arbitrator has a docket of cases. I have commercial cases and employment arbitrations in 2021, so those were not affected. But those cases in the next 3 months were significantly affected by this. So Mark, if you could just go back a couple more slides, thanks. And there we are, right there, thank you. So the way that I would characterize the last 2 or 3 weeks in my practice is chaos and crisis control. Initially, there was mass confusion by the parties as to exactly what they wanted to do. Just by coincidence, the vast majority of my docket in the next 2 or 3 months is public sector, primarily federal sector. So the federal sector, of course, had to call Washington, had to call their national unions to try to get clarity as to whether they would accept virtual arbitrations. And to some degree, I haven't even heard from them, but all of the cases in May have been postponed, and I'm waiting to hear exactly where we're going to go. So in a real short, in a nutshell, we have rescheduled all of the cases that I've had in April and May into June, hoping that we'll have the ability to either do virtual or face-to-face in June. There's been a discussion among all the parties as to what platform we would use if we go virtual. I've had to completely create for the first time a procedure statement in terms of how we would move forward if we do a virtual arbitration hearing. And interestingly, I found that there are different reactions between my client base, and in a nutshell, the public sector is much more willing to consider virtual arbitrations. The private sector is least amiable towards virtual arbitrations, and essential industries such as my grocery clients, the postal service, they're ready to go because they're open and they're wondering why I'm not willing to go to them face to face. My last comment is that I have not had currently any disputes between a union and management as to whether we should do a virtual arbitration or not. That's a very controversial issue. So I think in summary, the response of my practice is to understand the context of what we're dealing with. I've had to completely learn how to be a host with Zoom. A lot of my clients do not use Zoom. They use Microsoft and Skype and other products. So we're rescheduling cases into June and July. But I've also noticed there's been some settlements. And so the question is, has this prompted the parties to look a little harder in terms of settling these cases? And maybe it has. Thanks, Mark.
All right, so now are we we're opening up for questions? Correct? Janet, can you unmute your
Sorry,
mic?
benefits and challenges section. So Tom's taking the benefits.
Okay.
Benefits of virtual mediation. We're focusing on mediation first.
Sure. Yeah. Well, one of the things that actually the benefit right off the bat was that we can do meetings in this environment. You know, our agency had the capability of using Ring Central and some of these other platforms for years, but we'd used them primarily in the training environment, but not as much in the for actual mediation. So we were able to ramp it up pretty quickly and train mediators, and they found that it isn't the same as maybe looking face to face with somebody, but it definitely is better than not having a meeting at all if that's what you're faced with. And then, you know, in terms of the Ring Central platform, which is again very similar to Zoom, there is the ability to form breakout rooms so that parties can meet in the breakout rooms with or without the mediator or the co-host or the host. You can set up multiple rooms where you could have, for instance, in a collective bargaining mediation, you can have a management room, a union room, a room for the mediators to caucus if you have a co-mediator, and a sidebar room. You can set up as many as you want. So that works. You can share documents and share screens for that, which again is an advantage. You know, one of the things that we've found in terms of doing more of these sorts of virtual meetings, if you will, is that the person who's the host, and let's say that in this case the mediator for our agency, they actually have a lot of control of the process because they are, you know, kind of driving the platform, if you will. So, you know, the groups are kind of a captive audience. You know, that can have its pluses and minuses. You've probably heard or read articles about, you know, something called Zoom fatigue. It is fatiguing to look at these, to be involved in these meetings all day. But in terms of the process of the mediation and the meetings that we're having, in some cases, it seems that they can be more productive in the sense that the mediator is able to kind of direct the activity a little bit more than if they were in a physical environment. You know, you can jump into a breakout room and say, how you doing, you know? And so, again, not expecting this is going to replace face-to-face meetings, but it definitely has been a good, useful tool in this process. And obviously, in terms of travel costs and travel-related sort of expenditures and issues and logistics, it makes a big difference. So there isn't some of the customers that we are working with are saying it really is useful for them that they can turn on their computer and jump into a meeting rather than driving, you know, or arranging for rooms or whatever they had to do in the past. So we are getting some of that feedback. Guess that's what I have on that.
Great. So I will take over the next section, which is just talking through some of the challenges. And again, setting the stage here, I'm talking about virtual mediation. I'm seeing in the chat there are a lot of questions that relate to conducting virtual hearings, and Dick is going to be talking about some of the benefits and challenges of that. So again, keeping the focus on mediation for a minute. All of these bullets are framed in the way of sort of mediator actions. I want to keep the focus on what we can do versus thinking about what's the laundry list of problems we're all facing. I think for the most part, many of the challenges can be addressed. And again, this is not a comprehensive list. This is the list of the things that I've confronted we've confronted in a very small period of time. So looking forward to the open forum and have you add your challenges and also your solutions. I'm going to blast through this very quickly. This could be an hour presentation right here. So again, inviting people to contact us. And I'm happy to share any of my notes and any of my experiences via email or the phone. So let's just go through this. Facilitate agreement about virtual engagement and format. Obviously, the first thing you need is agreement that the parties are willing to do a virtual proceeding. I say facilitate agreement because I think the mediator can do a lot, as we do, in trying to unpack interests and concerns, what are the needs, and try and understand what is the reticence, what is the reluctance, or what is the refusal about. I think some of that, in my experience, can be addressed by the rest of these challenges and what we put into place But there is always the option of postponing if the parties both agree to do so. But I think for the most part, we should take a problem-solving orientation to this and try and understand what it is that people are reticent about. And I think for the most part, it's lack of information, lack of understanding how this will work. And once they have that information, people will get more comfortable. Once they agree, then there are questions about format and who's going to host, and are you going to use Zoom or something else, and who will be in control. I will just say, ultimately, we've found that, you know, the mediator, unless there's a way to co-host and the mediator can maintain control, the mediator does need to have control for a lot of the concerns that I'm about to talk about. But that doesn't mean you have to use the program that you're using. You know, we're trying to stay open, understanding that not everyone's using Zoom, for example, and seeing about getting up to speed with some other platforms, so long as the mediator is able to control the meeting in some key ways. Second bullet point, assess and shore up party readiness. We've been spending a lot of time as practitioners getting ready ourselves. But I think we have to also say, what can we do to support the parties showing up on meeting day ready to go? And I think if you wait until the beginning of the meeting to start addressing readiness for them, it can be very awkward. So working with parties in advance of the meeting, you know, you might think about a checklist that you would give to parties. You might think about an assessment that you would do on the phone as part of your pre-mediation work. You might consider a user guide. And again, we've developed each of these. So if anybody's interested to see what we've done, I'm happy to share it. But to give people some sense of, you know, best practices with the equipment, some of the basic skills that you need to start navigating, because again, it can be awkward to try and do too much coaching during the meeting, but on the other hand, we have to be ready to do that and to be flexible. But I think we can play as mediators an important role in helping people show up on meeting day ready to roll. Help parties acclimate to the virtual environment. This is not the third room conference floor anymore. This is not the HR department or the union hall. So I think just helping people when they arrive and everyone is saying we're not in Kansas anymore, taking the moment to sort of build into the process some elements here. First thing that people are going to start doing is scanning around and looking at people's homes, and you're going to lose your audience while people are doing that. So you might as well spend the first 3 or 4 minutes of the meeting and maybe build into your introductions. Again, this is more appropriate for mediation perhaps than it would be for an arbitration hearing. But you know, you can do things like let people, you know, show the coffee mug that they're using from home, say something about their background, because people are going to be looking at that anyway. I'm guessing there maybe even some people on this webinar are still flipping through the many pages to see who all's here. So, you know, we can build into the process some of the oddness or the novelty of this situation. I think the mediator can do a lot. We have to overtalk the transitions in the virtual world. It's very sort of jarring to get sent into a meeting room, into a breakout room. It's jarring to then be thrown back into the main meeting room. The mediator can do a lot to say, this is what you can expect at every point in the process. Make those transitions as transparent and open as possible and explain to people. Reduce and manage distractions and disruptions. Notice I'm not saying eliminate those. I think there's a certain amount of that we're going to have to deal with, but there are strategies that we can introduce to reduce and manage them. Some of the things that I think are distracting in a mediation that are part of the virtual platform is chat. And so the mediator should decide, are they going to, and it's also a security issue. So, you know, we've decided we're disabling that. We don't have chat going. Virtual backgrounds can also be very distracting. Lots of people are choosing to be very creative and have video going and all kinds of things. So again, rather than maybe trying to deal with that during the meeting, you might decide in advance you're not going to allow virtual backgrounds, and you can disable that. So again, these are just some things for practitioners to think about to reduce that. You know, what's going on in people's homes can be distracting, and we can do a lot, again, as part of that user readiness, giving people tips about, you know, choosing space. But again, we're going to have to just be flexible and live with some of that, as people, a lot of people have kids at home and have things going on. Somebody raised the question about side conversations via text or email. That is a huge distraction. Not only a distraction, it can be very problematic in a hearing setting. It can be problematic in a mediation. The approach I'm taking to that, again, I think what we have to say is, did we have perfection in our in-person meetings? You know, when everyone's got a computer on the table, do we really know that people aren't emailing each other in the middle of the mediation? I can guarantee that people do. But we can do a lot to set the stage when we're setting our mediation opening, laying out the expectations. And I take the chat and the texting and the email like a side conversation, which I simply don't you know, don't condone, don't allow in a mediation. People need to be giving each other their full respect of listening and not having those side conversations. So again, it's just laying, I think the mediator laying down the expectations. FMCS has taken this to the next level to actually have terms, you know, conditions for this format that parties sign off on. So I think that's another level that's worth considering. Bolstering platform and meeting security, Tom talked about that. All I'll say is know your platform, choose the right subscription level. If you're looking at Zoom, you know, what people are saying is that the basic free version is not as secure as a paid version. And then you've got to scan those settings and make sure that you've got all of the settings set in a way that's going to maximize your security, enabling the waiting room, do password protection. You know, I picked up from the Cornell website that, you know, don't send the password as part of the meeting invitation that's going to show up on someone's calendar that's maybe a shared calendar. Take the password out of the invitation and send it in a separate email to people as a way to have an added layer of security. We're all learning, and probably most of you have this figured out by now. You can lock the meeting. Now we've gotten into webinars where we have unions who want their members to be able to watch interest-based negotiations, for example. So the minute you do a webinar, then you're opening your world up to the public. But again, you can say, this is not a live stream. Please don't put this link out on your social media. Distribute the link via your email list so that it's going to a discrete number of people. And then, you know, as has been said, the minute there's the mediator retains a lot of control. You can remove people, you can end the meeting. We haven't had any problems with this, and we've done a fair number of these. But again, we're putting all those security steps in place. You know, I'm sure every mediator in the room has a story of how their mediation got bombed in some way. And I don't mean to use that word, bombed, but like Zoom bombing, right? Where, you know, people came into the room that weren't expected. I've been in downtown Portland and had somebody walk right by a ground level floor meeting and, you know, take their pants down right in front of a sidebar that I'm having there, you know. So we go get butcher paper and we put it up on the window. So again, I think we have to say this is our new environment. These are our new challenges, may not be different than challenges we face in other settings. We just have to be creative. So guarding confidentiality, again, this is another one. It's guarding it. It's not ensuring absolute confidentiality. Obviously, the mediator still has that obligation, but again, in a mediation, who's to say somebody doesn't have their phone on and they've got 10 other people conferencing in while the mediator's giving a presentation unbeknownst to you? We wouldn't allow that. We set the stage at the beginning. We tell people what our expectations are, and some of this is good faith moving forward. These are our expectations when we're in the room. When we're in the Zoom room, we expect to be talking to only the people who are in the Zoom room. Now, I will say, I think as we stay-at-home orders are relaxed, and we go to back to meetings with some social distancing, what's going to happen, and I didn't like this in the beginning of this with Zoom, you'd have 4 or 5, 6 people gathered, socially distanced in a conference room, but they were all gathered around one camera. And, you know, then you get into, you can't see everybody, people are talking on Zoom and you can't see them. So again, just protocols, asking people, please step into the camera. So we'll have another round of having to figure that out once we're using Zoom differently again, as we're getting closer together again.
Hey, Janet, just
Yeah.
looking at the time,
Yeah.
Kim asked, is there does the Oregon Employment Relations Board have an official guide, have an official guide for running virtual mediations and or any sort of official policy?
We have user tips. We don't have an official policy. I mean, we've stated to our constituents, this is what we're offering right now. Any proceeding from the ERB is going to be virtual at this time. So that's sort of our stance. We haven't developed anything beyond user tips and then sort of our own protocols for ERB mediators.
Okay.
Yeah, and just quickly, I'll wrap this up. So we all know about digital fatigue. I will just say we have to be creative with scheduling, creative with breaks. Thinking about larger blocks of time. An 8-hour meeting maybe is, 2 2-hour blocks with a 2-hour break in the middle. Again, how can you do that for a hearing? I'm thinking more of a, a facilitated negotiation, but understanding that people can't sustain for several reasons. I mean, we understand how the human brain works, and it's very, very taxing to stay online, especially when you're dealing in human interaction and trying to read people. The brain gets very tired because there's so much that we can't pick up on. But it's just also what people are dealing with in their homes. I mean, if you got little kids at home, you're not going to be able to stay locked up for 8 hours while they're out there. And then the last one, maximize human connection. We're all going to be looking forward to the day we can get back in our cars and go to mediations. I mean, I'll never complain about travel again, I promise. But I think there's a lot, this is a decent replacement for now, and I think there's a lot we can do to make it better. One of the things that I think we should all think about doing is setting our cameras so that more of us are showing, waist up, bring your hands into the frame. Again, we can't mandate that for other people, but you could certainly say as a user tip, set your camera up so that I'm not just, so that people are seeing more of you. I think you can sit back and you can lean forward. There are ways that you can use your body in this that communicate. In a mediation that I did recently, somebody came right up to the camera. One of the parties was really wanting to make a point to me, and she came right up to the camera. And I read that loud and clear that, boy, this is a high priority need for this person. So we've got some controls, and again, hands, that's the one thing I miss in this. And we can do more to be modeling and bringing our hands into the frame, seeing people in the breakout rooms. Yeah, so I think those are the main things. So with that, I'm sorry that took so long. I'm happy to hear more about your challenges when we get that chance. And I think we're almost there.
So thank you, Janet. In the time that we have left, we're going to move the conversation from video mediation to video arbitration. You can read these. I'm not going to cover them in any level of detail, but we're going to focus on benefits, challenges, and most importantly, what are the reasons that parties are reluctant to move to arbitration? But Mark, if you could just go back one slide. Just very, very quickly, I have noted a consensus by the parties that justice delayed is justice denied. That seems obvious, but it is not always the case, but I'm hearing that more and more. My docket is being triaged for discharge cases. So discharge cases are now taking and bumping other cases by the same parties. So I think that that's sort of an interesting sidelight of this whole process. The parties have noted that there's numerous guidelines that have been published by various ADR providers on how to do this. So I think the benefits are pretty obvious, particularly cost and the availability of dates by the arbitrator, because many of us in the West, we have to fly in an airplane for almost all of our cases. The challenges are pretty much what you would think. The Zoom scandal has come to the attention of all of my parties, and they question whether that's the right way to go. And to some degree, my federal clients will decide what platform is best. There's an issue of whether arbitrators should require payment for preparation time, particularly the first time you do a case with the parties. I'm estimating that it takes about 4 hours, and I've done 2 already. I estimate it takes about 4 hours of time to educate the parties, to of course, do the test arbitration the day before, etc. And my opinion is no, that it's an investment. Most of my docket is permanent panelists, so it makes sense for me not to charge. So I'm not charging any parties for the significant time that I'm taking to get them up to speed to do this.
Nice of you.
I think the rest of this is pretty standard. I think that it requires a little more of a collaborative spirit between the lawyers. Luckily, labor arbitration is much more civilized than employment arbitration, and I haven't had an employment case yet, but I think that the challenges are pretty much what you would think. Next, Mark. This is the more interesting discussion as to what am I hearing from the union lawyers and the company lawyers as to whether they want to do this or not. And the union lawyers are telling me that the grievant might feel a loss of procedural justice if they're not there face-to-face. They might feel a lack of catharsis at the end of the process. So they're concerned about that. The union lawyers want to confront the decision maker face-to-face. They want to talk to the manager who made the decision to discharge their client. The last bullet is important. My perception is a lot of union lawyers come a few hours before the hearing and do last-minute trial prep, and they may find that that's less easy to do under a virtual program. So what am I hearing from company lawyers and company reps? Of course, they're not sure if their client actually will agree to do a video arbitration, and they're asking. Many management lawyers tell me that they want to observe the facial clues, the body language of the witnesses, and believe that that's an important aspect of their role and the role of the arbitrators. Of course, there's the concern about inappropriate off-camera conduct, secret witness coaching, which you can deal with. I guess the bottom line is there's a degree of belief in the legal profession that witness demeanor is important for the arbitrator to see, and that arbitrators want to discern whether a witness is telling the truth or not through demeanor. I'm not one of those, but I'm sure there's arbitrators on this call that are. So in summary, time will tell, but it's not like mediation. My experience is that the parties are hesitant to go down this road. They need education. The question is, once the parties do a virtual arbitration, will it result in a tipping point? Will they embrace virtual arbitration into the future? Thanks, Mark.
All right, so now let's open it up for questions. Many of you have already submitted your questions via chat. Some of you, I said kind of I'd sit on them until the end. So I'm just gonna put them up on the screen. And if you have questions, continue to ask via chat. And if it's directed specifically to one of our speakers, please say so. If not, I will leave it to the panelists' discretion as to how they want to answer. So James asked, or commented that the VA, let me change the VA won't use Zoom because of security issues. I believe we've kind of addressed broad security issues, but can you talk about, in your experience, how specifically, again, you've addressed security issues?
Sure. Should I jump in on that first?
Sure, Tom.
Well, so we have had with FMCS similar experiences where, you know, there's the news stories about Zoom were all over the place, and because Ring Central, the platform we use, is closely associated, there were some agencies that said, we're not gonna, our IT department won't let us have the mediation using Ring Central or Zoom. Ring Central. So what we've done is, and this happened just recently, is we are encouraging the mediators in our group to use the platforms that we have the most, you know, control, if you will, over. For instance, in Ring Central, we have our IT people, they can go in and they can go into the settings, and they can turn some things on or off for all the mediators. They can turn some things that are, for instance, waiting room, they can make it be on it. So they're doing some things where there is some control for the mediators who are the hosts, and some of them, their control is taken away. The idea, what we're trying to find is the kind of the sweet spot between meeting security, ensuring those things as much as possible, but also not clamping down so much on the process that it doesn't feel like it's a real interaction, like it feels like it's just one way or something like that. So we're leaving some of that up to the mediators, and we're and these things are happening rapidly. And one of the changes that our IT department made a couple of weeks ago, where they locked up the chat function, that went over badly. So we had to reverse that pretty quickly, because in some cases it can be useful to take away the participants' ability to chat with one another. In some cases it can be useful. So with particular agencies, the other thing we did is we had our IT department vet a certain number of the platforms that we're not using, and they said that they were secure enough to use if the agencies insisted. So I put it in the chat, but Adobe Connect, Zoom, GoToMeeting, WebEx, Google Hangout, those were all the ones that our IT department approved. And then they also said if a mediator has an agency that says you have to use this, they can send the information, they can have the person contact our IT department, and if they vet it and it seems like it's secure enough, then they'll go ahead and say, yes, you can use that platform. So that's how we've tried to address it.
Thanks, Don.
And I would say we're just trying to be flexible with that too. And I've found when I've looked at some of these other platforms, they look very similar. So once you've figured one out, it's fairly easy to go, you know, I glanced over at GoToMeeting because I had a situation like that too, where a county local government was not willing to use Zoom. So, you know, looked at GoToMeeting, you know, now I noticed it didn't have the functionality, but it's something, again, if you can overcome that, you know, you can probably pretty easily get onto that. For us, we'd have the issue of cost because you have to buy, you know, a subscription to another platform. But for most of these, I think they're monthly charges, you know, so maybe you hop on for a month and then, you know, you just continue that until you need it again.
Mark, do you want me to answer the third question?
Yeah, so yes.
I mean, traditionally the answer is that it is the union who decides whether or not they wish on their behalf to go to our video arbitration. I don't see it as my role to contact the grievant or to ask whether the grievant gives permission. The union really handles that. They represent the grievant, and I'm sure that the union does that, but that's not something that the arbitrator would worry about, in my mind. Okay.
Mark, can I address the second question just briefly?
Yeah, please.
So it's a very good question, the tension between security and access. You said for public hearings, but I just would address this in general. There is a tension. And again, a couple of things that we've been working with our group in that have been very useful. One of them is to actually have we have these meeting techs that join a meeting like in Ring Central, and they're in the meeting, and their whole purpose is just to help troubleshoot issues that might come up. So for instance, a participant can't log in, it happens at the beginning of a meeting, and you have a participant that just can't get on in their phone or their computer. So the meeting tech can actually, the mediator can continue to run the meeting. The meeting tech can work with that participant, get their phone number, call them, get them online. So that's one of the things that's been useful. And then in terms of what we've been telling the mediators is that in terms of security, it's very important that they keep track of their participants at all times. And there's a participant window in most of these platforms that you can see. And then you have actions you can take. You can mute participants. You can remove a participant. And if you set up your settings correctly, that participant cannot join the meeting again if you need to. You can lock meetings, like, as I said earlier, after the participants that have arrived, that you're expecting have arrived. You can look at the chat function and make sure people are trying to get a hold of you can. You can use the waiting room, which is a very useful tool to make sure that you have the people, again, in the meeting that are supposed to be in the meeting. And then there's screen sharing options you can set up. You can set it up where people can't share their screen in case you're worried about that security end of it. I believe you can set it up where people can't use a virtual background. That's kind of controversial because some of the ways that the Zoom platform has been bombed is people putting things up on the green screen that are a virtual screen that's inappropriate, running a video or something that's offensive. So there are lots of things you can do, but the main thing that one of the most important things we're telling the mediators is to use that participant screen, and also if you have another person with you from the agency, for instance, have them be a co-host, and the co-host can help with all of the sort of meeting technical functions while the mediator is trying to run the meeting or whatever your meeting is. So I hope that answers some of those questions. And
then can we go, I don't think anyone's addressed, have you, any of the panelists, have you been in a situation where a translator was necessary?
Not yet.
I have. So we are actually trying to address this a little bit better, but the initial way we address this is that we just did a quick poll of our meeting text to see the language that had come up that we needed translation for was Spanish. And did we have any meeting text that spoke Spanish fluently? Turns out we had like 6. So we, on a technical side, to make sure that people who English wasn't their first language and Spanish was, were able to assist that. The other thing that we haven't gotten to, though, is a service that you could utilize where, and I know they exist, but we haven't really connected yet with one that I know of, where translators are available and they assist parties in whatever language they need to communicate with as part of the meeting. And again, I know they exist, but we haven't gotten to the point of actually connecting with one of those groups yet that I know of. It's something we're talking about.
And so Philip asks, and I think I'm gonna generalize this, but after this, can you guys share whatever video conferencing guides are available through your respective agencies?
Sure.
So yeah, so Philip, I think we're gonna handle that we'll include that as kind of an appendix. How do you deal with vulnerable parties where emotionally difficult issues arise?
Well, I guess, how would you deal with that if you were in a actual meeting? I mean, that, to me, I think you deal with it the same way, right? There are some things that are different about the platform. Obviously, you're not in the room with them, but I don't know if that's a great answer, but that's the answer, is that you would use the tools that you would use if you were sitting in a room with somebody.
And
You know,
Mark,
I'll jump in and say, this question begs the question for me, will we keep doing this after this crisis is over? Will we continue to offer? Will it continue to be acceptable in every situation? And I think where you do have disputes that are highly emotional, you have a lot of people, I think it's very difficult. And I think, you know, we're making the best of it here. But there may be situations where you don't want to offer virtual mediation because it's just too difficult. You need to be in the room managing that. And maybe there's some combination where, you know, we can get through certain level of issues in person, and then we can combine it with a virtual meeting or two, and then come back to in person. So I think it's going to give us some nice flexibility down the road.
That's a great point,
Dick,
Janet.
I think I cut you off.
well, the answer you gave equally applies to arbitration. I hear this all the time, particularly from the union lawyers, that this is a reason for them to hesitate to move to virtual arbitration. And there's also the perception that just some witnesses will get flustered when they see themselves on the screen.
Right,
You know, they don't do this for a living.
right.
So there's just a lot of concerns about witness issues. And the other issue that we talked about 10 minutes ago is partial attention. There's also a lot of fear by the advocates that if the witness is at home in their bedroom or their kitchen or whatever, they'll be much more distracted and not listening to questions. Thanks.
And let me just add one more thing on this question with mediation. You know, you can do breakout rooms, and again, you know, you can do 100 different breakout rooms. So, you know, the mediator can step into a room with 1 or 2 people if that's needed. That does provide some intimacy, I think, more than if you've got 20 people on the screen. You can always pick up the phone on this too and say, you know, let's have a phone call. And that could be another outlet to try and break through or to help somebody through an issue. It's got to get creative. Some people are saying on the chat, which I think is a good thing to point out for everybody, that Zoom and some of these platforms do provide a lot of technical assistance. So the Zoom Help Center is a great place to go. And I think NAA actually put a link out when they did their training to the like a 37-minute overview of hosting Zoom meetings. It's a great thing to just sit through and get yourself acclimated.
Yeah, they've also offered webinars periodically that you can take part in, and they're very, very knowledgeable, or very,
Yeah.
very informative.
And Emily will be sharing the slideshow after the soon, and I think we'll add something at the end, which again, just some quick guides that we're aware of for those practical tips, if that's what you're looking for.
Mark, another issue with witnesses concerns whether every witness has internet connection in their home, whether they have the technology. So that's just yet another concern about doing this in arbitration.
Yeah. And likewise with mediation, I think we really have to check our assumptions about people's readiness because, you know, there are a lot of folks that we serve that don't sit behind computers all day. And for them, number one, do they have the equipment? Number two, you know, are they going to be comfortable and familiar with using it? And I think giving people that chance to get up to speed prior to the meeting, if it's even possible, you know, there could be equipment or internet connections that are barriers too.
We didn't mention this in this panel, but the assumption in arbitration is that you have to do a test. Maybe it's the day before or a few days before, but most of the parties who are going to be in the hearing need to be on to make sure that they have the equipment and they know how to click and how the whole process works.
Yeah.
Well, that's a great point. I'm sorry I didn't mention that, but one of the recommendations we're making to the mediators who are holding these meetings is to have a test run a few days before their actual mediation where all the parties try to get connected and they just make sure that basic connectivity is there. It's a very good point.
All right, I'm going to have to intervene with a heavy foot. and acknowledge the clock. We are a bit past time, so thank you, everyone, for those of you that joined us. Thank you very much, panelists.
Thank you, everyone.
Thank you very much, LERA. I
Thank
do
you.
want to put another plug out for the dispute resolution section. If you want to hang out more with our wonderful panelists or people like them, please sign up for the dispute resolution section. And we're happy to have you. We're growing. We want to continue to grow. So if you haven't heard of us, check out the LERA website. Most of our contact information is listed there. And we're a very broad tent, academics, practitioners, both all sorts of neutrals, lawyers, advocates, union representatives. It really spans the gamut, and the cement there is simply, are you interested in dispute resolution in the workplace? So please reach out if you have any questions or concerns. Otherwise, thank you very much.
Thank you. Thank you, everybody.